Home rule. The relationship to Illinois. Some of this is going to be reading. Some of it might get dry. I'm going to try to break away so that I can make this as entertaining as possible, but I have found sources. This is from the Illinois Municipal Policy Journal, titled Taxes and Trust, Constitutional Home Rule Authority. Why is any of this relevant for communities in Illinois? Many elected officials and staff in the state regard home rule as a good thing because home rule cities, villages, and towns face fewer obstacles to achieving progress than their non-home rule equivalents. However, in a fashion not dissimilar from Michigan, and as will be discussed in detail later, voters in Illinois have on few occasions voted to approve referenda that strips their local governments of home rule authority entirely. Likewise, a significant number of referenda have been held by communities not included within the institution in the initial constitutional grant. Some have been successful, but most have not. Rhetoric such as blank checks and trust inevitably emerges in these referenda, with citizens sometimes questioning the motives of their elected government. Given the lack of political will in the state legislature at present, it is likely that the subsequent efforts to gain or maintain home rule will be strictly local. Indeed, efforts this year to expand home rule to smaller communities have appeared to stall in Springfield, as a joint resolution to that effect appears to have been placed in the Rules Committee. Illinois General Assembly 2016. On that note, talking to some of the people I have been in family and friends circles, it's like, well, I don't trust that they're going to do the right things with it. Okay, well, you can give the power of home rule to the people in charge, right? And you do that pretty permanently, right? Or you do that, you give all the powers to them, right? But let's say you've got some people, let's just give the benefit of the doubt that you have some people in there that can make the right decisions, okay? Imagine how difficult it must be to have people who, let's say 10% of the village is affected by alleys, and they want those fixed, and that comes at a cost of $1 million, okay? Now they have to find where they're going to raise $1 million, while under state control having a $200,000, as Kathy mentioned, a $200,000 roughly intake of taxes from hotel motel that you can only spend in certain areas or on certain things. So they're handcuffed a little bit there, and then the arguments that I've understood before is, well, just take it to referendum. Like, if the people understand that this needs done, then let's take it to referendum. Well, you have 10% of people trying to get the other 90% to agree to a referendum to raise taxes or to put a tax in place so that we can raise the money to fix the alleys correctly so that their stuff doesn't flood and that makes their life a lot better, and they voted down. Okay, so now you have no budget for the alleys to be fixed, and they continue to deteriorate, okay? We all have to take responsibility for our town. And if people are driving through the town and looking around and all they see are blighted streets and rundown alleys and this and that, then it directly affects you whether you like it or not. It affects our real estate values, the overall feel of the town, the overall investment in the town when it comes to commercial businesses. It will have an impact, and I think that there's more people I could probably talk to that have been here longer that have seen those waves of impact, and I certainly don't know everything when it comes to that about how different things over the years have affected us and not. I just know that things always haven't been managed as well, and that's frustrating, and it is. And then to say that we're going to just hand you these powers, I get it, and that can be tough too. So the remainder of the briefing offers 4 findings supported by legal and policy research that can provide elected officials and managers with a brief overview of the development of home rule in Illinois, including some legal challenges to that power, and the analysis below provides readers with a view of ballot efforts to both strip and grant home rule authority. Finding 1 states that through a grant in the state Constitution, Illinois home rule communities enjoy some of the strongest powers in the nation, as set forth by the Constitution's framers and largely upheld in the courts since 1970. However, municipal leaders and staff in communities that are currently not home rule must decide for themselves if pursuing home rule is an important goal. Students of the history of home rule will certainly remember that absent contrary legislation or constitutional provisions, municipalities are political subdivisions of the state, and as such can only exercise the authority of the state expressly They can only exercise the authority the state expressly grants to them. This is the example that Kathy gave. This came to be known in the United States as Dillon's Rule, named after an Iowa Supreme Court justice known for taking a hard line against local units of government attempting to exercise authority in the 1800s. Such onerous constraints were imposed by Dillon's Rule that the city of Chicago required an act of legislature to enable its first zoning ordinance in 1923. The rule was so stringent that representatives of the city of Chicago were forced to travel to Springfield to lobby the legislature to allow the city to issue permits to peanut vendors on Navy Pier. A floor debate during the 1970 Constitutional Convention also referenced a similar colorful example of Chicago later having to approach the legislature to approve the shade of emergency lights to be procured for police squad cars. Now, I think that more has been done to make that not really an issue. I think that there's probably a little bit more leeway. One leeway that you're seeing, or one thing that you're seeing, is where state mandates. Don't get it twisted, guys, because state mandates that 3-cent sales tax or gas tax that we just implemented. That's a given from the state. If you listen to the podcast, it's been said 2 or 3 times in those podcasts that that's something that was given by the state for municipalities that are non-home rule to do, and that is raising money for us that is very much needed. And so, is that an area where they'll tax further? I don't know. That is one of the areas that a couple trustees have mentioned you can get more taxes from. But again, you can't just sit there and say that, oh, well, it's 3 cents, it's 5 cents, we won't feel that. And it's about being fair, and it's about understanding the budget and understanding that, yes, we feel it, we recognize it, because there's residents that are going to say, oh, well, I go here to get gas, or I make a point of going outside of Westchester. I don't always agree with that, although I get it. I get that you can go elsewhere to shop. And if you tax the things that are at Mariano's and Jewel and those kind of places, then yeah, we're going to feel it as residents. But how much, what's the percentage? We don't really know. We don't know how, there's no way to calculate how many people are spending money, and those taxes that are out of village are coming to the village. But I can tell you, one example would be like Hillside, and we've already talked about this, I think, is where they got the Target and all that big development as, from a TIF and from the ability that they have with home rule. So I get it. That I don't know much about that. It's just an example, and possibly there's a lot that went into that I don't know. So I'm just basically the stupid man's idea of an example, or the ignorant person's idea of an example, because it's all we have right now. I mean, you have to do a lot of work to get down to every example and make every little debate and argument. So I'm just going off of these examples. So moving on, though, I wanted to talk a little bit more in this particular article, if you will. The finding 2, the fear of new taxes and resident tax burden can prevent communities from gaining home rule. Historically, perception of abuse of home rule taxation power has led several communities to vote to rescind home rule, though these have been isolated cases. As can be seen in Figure 1 below, the number of communities with home rule generally grew at an appreciable clip during the first 4 decades of home rule's existence in Illinois. Interestingly, a record 49 communities became home rule during the decade of 2000 to 2010. A further analysis of Illinois State Secretary of State data shows that 75% of these occurred between 2000 and 2007, which speaks to both new municipalities exceeding 25,000 residents due to population shifts, as well as others seeking to resolve challenges related to that growth, along with land use issues and intergovernmental agreements. I tend to think it's interestingly, just before the recession. I don't know what that says, or what, how that could be linked, but likewise, growth in home rule status appeared to cool during the recessionary period of 2008 to 2010. During the initial burst of automatic home rule grants and subsequent referenda in the 1970s, excitement about new home rule powers greatly outweighed distrust. During that time frame, in fact, 88 communities of less than 25,000 residents held home rule referenda, and 60% of those resulted in home rule status. Illinois, however, was not immune to the undercurrent of government mistrust and dissatisfaction with taxes. During the late 1970s and early 1980s, so-called taxpayer revolts began to brew around the country. Citizen groups such as National Taxpayers United of Illinois, located for many years in the Chicago suburb of Berwyn, began in the late 1970s to advocate throughout the state not only against higher taxes but also against home rule, calling it home ruin. The founder of that organization would regularly ask citizens of both home rule and non-home rule communities whether they could trust elected officials with the blank check represented by home rule powers. Efforts like those of the NTUI enjoyed early success in Illinois, causing citizens from 4 municipalities to petition through a ballot initiative to formally rescind home rule status: Lisle, Villa Park, Lombard, and Rockford. Then, the second largest municipality in Illinois, Rockford's home rule rescission raised perhaps the most concern out of the 4 in municipal circles. Though its population at the time was nearly 140,000, activists were only required to gather 10,800 signatures to get the measure on the ballot. It is not hard to imagine a voter with even an average aversion to additional taxes easily voting for such a provision, particularly if it is presented in a vacuum with no warnings for such a provision. Vacuum with no warnings of what might occur in several years or decades' time. Let me read that again. It is not hard to imagine a voter with even an average aversion to additional taxes easily voting for such a provision, particularly if it is presented in a vacuum with no warnings of what might occur in several years or decades' time. Quantification of any negative externalities affiliated with Rockford's vote to date would probably require an intensive study, as would the outcome of any policy measure. However, a foreshadowing of the challenges which lay ahead for Rockford was perhaps felt by the city's already non-home rule school district the following year. A Chicago Tribune article at the time noted that Rockford schools faced a complete shutdown of extracurricular activities absent the passage of a tax increase referendum. One resident interviewed stated, "It doesn't take much to knock down a tax around here." In Rockford's case, the home rule negation ballot initiative also coincided with a recent doubling of a tax that was unpopular in some circles. Lisle voters, on the other hand, voted out home rule the year after the village board approved construction of a new city hall building, despite many citizens believing another city structure could be renovated for less money. Now, I need to stop here because that is absolutely one of the things that I said to Frank Perry, and I think I said it on the way out to the car, so I want to bring it up here, and that is that's the last thing I would want to see, and that would really get voters riled up, is that you pass home rule and then you turn around and you say, oh, we're going to move out of the building we're in because we want to let that be a space for economic development, but we're going to build this Taj Mahal over here. And I've seen that happen. I mean, I've seen village halls that just don't need to be the way they are, and it seems egregious and silly. And I had a job in which I was a salesperson who would go around to some of the village projects and try to convince them that they needed my service on their project. And in doing so, I would see a lot of village libraries and village buildings that, while grandiose and great to be in, probably weren't as necessary as some of the things that villages need to keep houses from flooding and water main breaks from happening and streets not being ridiculous to drive down. So if you have all those things in order, great. Bring it to the people and say, hey, we want to build a really comfortable building for all of our employees to be in and things like that. But I think you do see those powers abused, and I think it's unfortunate. So the experiences of Lisle and Rockford show that voters have the capacity to punish elected officials for a prior unpopular action, particularly those involved in finances, by negating home rule, under the arguably misguided principle that each citizen, and not the officials they elect, is best situated to decide every issue facing the municipality. This is in essence the trust idea set forth by NTUI and other like-minded organizations discussed above. In reality, as every elected official and municipal staff member knows, the average citizen has neither the time nor the inclination to participate in every decision that a home rule community makes on a day-to-day basis. Thus, a good argument can be made that a vote against home rule is a vote against efficiency and efficacy. However, there is nothing in the Constitution to prohibit a municipality from regaining home rule after having voted against it. Again, this is something that I've that I've been saying, is that we have to focus on the people that are in those positions. I think if this is going to be, regardless of whether it's going to be shot down or adopted, we should be focusing on the people. But I'm putting something like this out there, and I'm showing you the numbers, and we'll continue to do that all the way through this ever important vote. This podcast was never meant to be just about this, but this is one of the biggest topics that we could be rallying around. And I have 57 subscribers and 85 likes on something like this. So, imagine the frustration of the village officials, if you were one, of seeing the numbers at your meetings and seeing that people are blasting you for not putting out information or not trying to put out information when you have every best intention to. Maybe they don't, but maybe they do. Let's give them the benefit of the doubt and try to be positive here, that they're trying to give the best advice or understanding of this as they can. And they're limited by what they can say. They're limited by what they can promote, what they can say in terms of swaying voter minds. So anyway, perhaps they're trying. Perhaps they're not trying enough. But my intention with this was not to come in and beat them over the head for not trying hard enough. And why didn't you get it out? I challenged them on that idea. Why didn't you put this out sooner? Why didn't you try to tell people that home rule was coming up and give us the time to wash this out to where we can say, okay, we have a great representative of voters that can vote on this intelligently. I think instead you're going to get out of 16,000. I'm going to make a prediction right now. Out of 16,000 residents, let's say that 8,000 of them can vote. I don't know what voter turnout will be. I'm gonna call it at about maybe 2,000, maybe 2,200. I think that's even generous, but we'll see. Hopefully not. So to keep going, finding 3. I actually mentioned this in one of the podcasts, but communication with stakeholders is critical. Sure enough, this is the one that we're just talking about right now. Communication with stakeholders is critical for communities weighing the possibility of pursuing home rule status through a voter referendum. And once secured, home rule can offer officials and administrators powerful tools to tackle large infrastructure and budget challenges. An excellent example of this can be found in the municipality of Highwood, a northern suburb of Chicago located in Lake County. Highwood's village manager noted recently that his municipality held 2 home rule referenda over the past 20 years, one in 1997 and the latter in 2006. The first was unsuccessful because, as the mayor at the time noted, officials wrongly believed that the need for home rule was a no-brainer. Officials and administrators did not make this mistake the second time, holding community meetings and interviewing business owners to communicate what home rule represented for the community. Also, all of the surrounding municipalities had home rule at the time and had sales tax rates higher than that of Highwoods, further strengthening the case. Residents were sold in part by the fact that a potential home rule sales tax would disproportionately impact visitors to the town's many noted restaurants, broadening the tax base. The village manager noted that Highwood successfully used home rule last year to fill a budget hole related to the operations of the fire department and also to issue bonds for a historic $5 million capital project initiative to replace a 100-year-old road infrastructure. Communication also featured prominently into more recent home rule referenda. Of the 3 ballot initiatives to institute home rule in 2015, for instance, only one was successful, perhaps in part because it was tied to a critical issue: water. Shorewood officials communicated to voters that underground reservoirs from which residents drew their well water were becoming depleted. The officials launched a campaign for home rule, stating that with home rule they could generate enough tax revenue to fund a pipeline to receive Lake Michigan water from a neighboring community. The referendum passed and the community began efforts to fund the pipeline almost immediately. The village of McLean, however, was unsuccessful in tying its referendum to the replacement of an aging water tower. 2 other referenda were pushed by officials seeking to implement a crime-free housing ordinance to better hold landlords accountable for criminal behavior occurring on their property. Although home rule certainly would allow a community to pass such an ordinance, provided that the state has not preempted the area, and as discussed earlier, it is possible that voters were cautious about the other powers, particularly taxation, that home rule granted. Another factor may be opposition from Illinois Realtors, an organization which lobbies on behalf of realtors throughout the state, and which generally opposes home rule due to an opposition to the raising of transfer taxes made possible under home rule. only by referendum. I need to make that side note. That I just talked to Mike and he agreed that that is one of the laws that had been passed, is that even though you're given home rule, you cannot implement a real estate transfer tax. And I disagree with Frank in his comment online that stated that that would not make a significant difference. I think it absolutely would. I think $3 per thousand, which would be low or average on a sale of a home or property here, would have a big impact. And so as people come and go throughout the city, I think that's a very good point to make, is that we have to agree that that is a tax that we agree to. And I certainly don't feel like that is a good idea. I'm in the business. I hate it. I hate being taxed to sell a property, because it's not always a homeowner. And why would you want to hit a homeowner anyway? I mean, why would you want to hit a homeowner on the way out, and why would you want to hit an investor who just took your property from 140,000 to 300,000, and now you hit him for selling it? It's ridiculous. But that's a soapbox I don't want to get on, but I just want to express at least that I do have some opinion in that regard. So so that's it. I think conclusion, as this briefing shows, it is important for elected officials and staff at municipalities within the state to be aware of some of the forces that can conspire both for and against home rule, and history reminds us that at the end of the day it is a highly political issue, and rightly so. Home rule is one of the strongest tools a municipality can wield in the pursuit of its objectives on behalf of its residents. Despite the severe hardship faced by many in Detroit, it is perhaps too simplistic to conclude that this city could have avoided bankruptcy if it had not been stripped years ago of certain home rule powers. However, at a time when a significant portion of this electorate feels disaffected with the state's affairs and a legislature that has ground to a halt, it is certain that many home rule communities shudder to think what might be if they had to bring every decision to a ballot referendum or to Springfield for approval. Okay, I don't know. For or against, whatever. That made some good points. Hopefully I added in a few good sidebars there. We're coming up on 40 minutes already. But I had to address some of the things that were initially already going on, and now I'm trying to get to some real good information for you people. You can look this up. I have the links on my on the YouTube videos. If you click show more, the links are there. I'll also post the links within the group, or the page, Westchester Informed page. That is also somewhere that I'm going to stick to and stay. So if you like that page and follow it, you'll see those updates, and hopefully we can grow this as fast as possible. Again, probably will not be commenting anymore or getting involved in the commenting. I'll just stick to the page and informing you guys what's up. So home rule powers. This is an educational brochure. It says summer 2004. Home Rule and You from the Citizen Advocacy Center. There are some things I read through this whole document, and I'm going to post the link, but there are some things that I highlighted as I went through that I thought were important. So I'm just going to read those. But locally, let's just get started right away. Locally, a home rule unit may impose restrictions on its home rule powers. For example, home rule units are allowed to increase property taxes beyond the statutory tax cap. In response, Oak Brook Terrace voters persuaded the local governing body to pass a self-imposed property tax cap. Now, I thought that was interesting because a lot of people say, oh, well, passing your own ordinance or property tax cap doesn't hold any weight. I don't know. Other towns have done it. So, I'm just looking at both sides of it. I get that you don't want property taxes to go up, but then again, if they say that they're willing to put a cap on that, we don't know what's going to happen down the road. We don't know what these board members are going to look like. And hopefully Westchester Informed continues to bring you good interviews with not only candidates, but the people in power. So that way we can get informed about who these people are and what their character is like. Because being independent, I got no reason why I can't sit down and make a judgment of their character. And hopefully we can get to the point where we see video of them so we can see how they are in a different light, in a different way than just on the sort of campaign trail. And hopefully that's a good thing. Home rule and taxes. I highlighted that home rule has a number of uses. However, it is most commonly used to generate revenue through its broad taxation powers. Home rule units can constitutionally tax anything that is not income, occupations, or earnings. So some of those are municipal retailers and service occupation tax, hotel motel tax, gasoline tax. A use tax is a tax on all tangible property that is registered with the state. For example, new or used cars, boats, or other vehicles. Cigarette taxes, property taxes, a real estate transfer tax we talked about, food and beverage tax, amusement tax. So this is a big list that they can tap into, and I get it, especially with the gasoline tax, and the use tax is an interesting one. I certainly would not want them taxing buying and selling a vehicle that's been registered. There are some people, you've heard of the state doing that. Actually, I heard the state did that, where they're taxing a used car if you both when you buy one and sell one or something, or when you trade one in. Now they're taxing it. I mean, I don't know. Like, yeah, I'm certainly not for that kind of crap. But if you can get stuff together and you can be reasonable with these, then let's keep talking. But who's to say whether that's actually gonna be the case? When Downers Grove obtained its home rule status, the village council instituted a home rule policy to address citizen concern regarding the potential abuse of power. The policy reads that prior to the adoption of any ordinance imposing a home rule tax on any person or property in the village, not including property tax extensions, the council must publish for general circulation a statement about the proposed tax, as well as an explanation of how the revenue will be used. 7 to 10 days later, the council is to conduct a public meeting regarding the proposed ordinance. The council will not vote on the ordinance for at least 2 village council meetings, allowing citizens enough time to submit a petition opposing the ordinance. The petition must contain 10% of the voters from the last mayoral election. So guys, again, if you're not thinking that these people are doing their homework and are being reasonable, these are the things that other towns have implemented. Downers Grove, I mean, what a junk town, right? I'm joking, obviously. I mean, I consider that a very upstanding and great town. I mean, they've got great schools and all that good stuff. But I mean, this sounds similar to what Kathy said, and what people are saying is that we want to try to put in safeguards. We want to try to give you guys the power still, while being able to shift and move as we need to, so that we don't have to bog up the system and bog up the employees and some of the people that are already trying to make this village run smoothly. Perhaps that's the reason I can't get in Paul Nosek, is he's up to his eyeballs in stuff that he has to do just to keep the village running back on track, as they say that they're doing. We'll figure that out. Let's figure that out together, whether or not that's the case. So I welcome you on, Paul. So moving on to, and this is, I think I said where this is from. So this was, it talks a little about Wheaton, Harwood Heights. One of the things I highlighted, for example, when Villa Park repealed home rule in 1980, it had to restructure its debt to meet statutory requirements. This restructuring raised the community's debt costs and forced an increased tax rate. Excuse me, I just had to take it's a lot of talking, but hopefully you're finding some value in reading these sources of information instead of just forcing you to go out and find them and read them. When Rockford repealed the home rule in 1983, its property tax rate was cut back to non-home rule level. To make up for lost revenue, the city went to referendum to raise the tax rate back up to the home rule level. In this case, tax levels were not decreased, but voters were allowed more citizen input. Okay, that is that source. Now, the last source I have, which is probably one of the larger ones, it's the Municipal Handbook from 2018, Chapter 2 on Home Rule and Intergovernmental Cooperation. What does home rule mean? Home rule gives local governments power to act autonomously. These grants are made either through state constitutions or state legislation. Most states have provisions for some form of home rule. Very simply stated, a non-home rule municipality must show a specific grant of legal authority in order to exercise a power, while a home rule municipality may usually take an action unless it is specifically prohibited or preempted. Now, I'm probably going to get to this, but I'll just also give you a quick example of this too, is that if the village of Westchester, and this is a very egregious example, but if the village of Westchester wanted to say that the drinking age was 18, they couldn't do that because it makes state law and state regulation less uh, stringent. So that's preemption. So basically, as long as it is a law or rule or ordinance that doesn't give less, how do I want to say this? So as long as the state law isn't more strict, does that make sense? So like in terms of, um, I guess in terms of things like not only like the egregious example of like a drinking age or something like that, but if you so let's say, I think this is a good example. So let's say you had an, a state code that said that you had to have 3 fire alarms in your house total, and they had to be in certain locations. If the village wanted to say, nah, like one is fine, and it can just be in the kitchen, I'm pretty sure that would not be allowed because it's the state preempts the code as to what they can and can't do. But in terms of how much you have to pay for that permit when you're doing a renovation, that's of course up to the village. Um, Let me just read some of this, I guess. Life before home rule powers. Well, that's just the history. I think it's something that you should look into, is the history of home rule. But this talks about life before home rule, the beginning of home rule powers. How can a municipality obtain home rule status? I think we already know through referendum. Oh, let me read this for sure. A petition must contain the number of signatures that is equal to or greater than 8% of the total votes cast for candidates for governor in the preceding gubernatorial election. If the referendum fails, a new vote may not be taken for 23 months. That is discussing municipalities rescinding. Municipalities with a population of at least 25,000 automatically have home rule powers, and smaller municipalities can achieve home rule status by the majority vote of citizens at a referendum. No other county to date has a referendum voted to become a home rule unit. So counties have not voted to become a home rule unit, but the referendum may be initiated by either a resolution of the governing body or a petition signed by qualified voters. So it's basically saying how home rule can be enacted. And so then if the referendum fails, a new vote may not be taken for 23 months. Interestingly enough, we voted it down in 2016, and here it is again. So we will not have this option for 2 years. So also consider that. I mean, while we don't want to be taxed, things will have to go to referendum if you want them fixed. Otherwise, we see another 2 years of possible deterioration or possible frustration by employees and trustees that otherwise would have done a good job but get frustrated and now don't want to deal with it anymore. So, and I get that. I mean, you've got to be, there is in some cases some burnout here where you're trying to do good for the village and you just get frustrated and you move on, and when you were the right person for it. And so again, $5,000 a year is what the trustees are being paid, and hopefully they're not hopefully, I'm pretty sure they do way more than that sort of pay. Does each municipality that automatically becomes home rule through population growth have to accept it? No. Or yes, I should say, but the municipality can still decide by referendum not to be a home rule municipality. An election to change from a home rule municipality to a non-home rule municipality may only be held once in every 47-month period. So let's say that we vote to become a home rule municipality. Okay, now we have 47 months, well, essentially 4 years, before we get to vote on that again to rescind it. This begs the question, though, and I am interested in this if somebody listens to this and the trustees want to put in place something that would trigger a referendum for home rule to be repealed. But so this pertains only to population growth. So let me take that back. So pertaining to population growth, you're automatic unless you rescind it, and then it can only be held for every 47-month period. I'm interested to know if that is something that's in place for passing a referendum for home rule. So once you pass it for home rule, then can you not rescind it for 47 months? I don't know that that's what that's saying, but it would be interesting because then whatever ordinance you put in place it doesn't matter if it triggers a referendum for rescinding home rule. It can't be done for 47 months. So interesting. I got to figure that out. If somebody wants to or has any knowledge on that, definitely send it out. What are the specific home rule powers granted by the 1970 Constitution? A home rule unit. I've said this too many times in the podcast. That's just the definition of home rule and what powers they're granted. Most of them. Taxing, debting, public welfare, those kind of things. But you know what? I don't know. Let me read more about this because I think it would be important for people to understand. This provision unshackles home rule municipalities from being required to find legislative authority for every action. Further, every law that is enacted may not deny or limit home rule powers or functions unless there is specific language limiting or denying the power or function. If a home rule municipality is considering a matter involving its government and affairs, its officials will have the broadest power to deal with it, limited only by constitutional due process and equal protection requirements and preemption by the General Assembly of Illinois. In addition, the General Assembly has provided that this power may be exercised notwithstanding the effects on competition, which lessens the exposure of municipalities to antitrust suits. The issue therefore becomes whether, in any given situation, the exercise of the power or the performance of the function pertains to the individual municipality's government and affairs. Many powers and functions obviously relate to the government and affairs of the municipality alone, and just as clearly others do not. For instance, municipal actions that impact how other governmental entities are to function or attempt to modify the judicial system do not relate to that municipality alone. Thus, a home rule county could not pass an ordinance relating to the frequency of tax payments to all governments within the county, and a city could not control the manner in which objections to the enforcement of its ordinance would be judicially reviewed, or affect the law on garnishments. So a municipality could not pass an ordinance requiring courts to order a losing party in an ordinance enforcement case to pay the municipality's legal fees. So this goes back to like what's preempted by Illinois or by the General Assembly. So for situations in the gray area at the edge, the courts have established criteria to be used to determine the proper assignment of the power between the municipality and the state. Specifically, courts look to the nature and the extent of the concern being addressed. 2, which units of government have the most vital interest in the solution of the concern addressed. And 3, the role traditionally played by local and statewide authorities in dealing with the concern. The court has applied these factors to uphold the municipality's authority to enact and enforce fines against a public utility for raw sewage discharges, even though the state also regulates utilities under the Public Utilities Act. On the other hand, a home rule unit may not disregard the Prevailing Wage Act in awarding a contract because it is considered a matter of statewide interest rather than local concern. In addition, branch banking is a matter of statewide and not local concern. Again, this is getting into stuff that's kind of like, what do they mean? So it's very detailed, but a home rule unit may frequently exercise powers concurrently with the state. A home rule government's power to regulate for the protection of public safety includes the authority to enact ordinances that address matters already covered by state law, as long as the legislature does not limit the power. Even comprehensive state regulation, where there is no express language of exclusive state control, will not be enough to deny home rule powers. An example of an area of concurrent authority is the area of liquor control, except that home rule municipalities may not lower the minimum drinking age. In the event of concurrent legislation, the court must enforce home rule ordinances, even if they are more stringent than state law. So that's what I was trying to say, is where state law can be less stringent, but only in certain areas. So let's say, go back to the example of the 3 fire detectors or smoke detectors. The municipality can say, no, you need 7, but they can't say, no, you need just 1. So I'm pretty sure that's how it's read. Let me see how we're doing on time. So again, we're approaching 58 minutes now, approaching an hour. I get it. I'm going to keep going because I think some of this is very important. This is the stuff that's sort of dry. I'm trying to do my best here, but this is the stuff that is that I've found, at least, that was sort of influential in making these kind of cases for and against. In which areas may home rule municipalities exercise their powers? Public health, safety, morals, and welfare. So unless specifically restricted by state law or other provisions of the Constitution, a home rule municipality may pass ordinances regulating the areas of building, zoning, sanitation, nuisance, civil disturbance, and all other matters of public health, safety, morals, and welfare. A home rule municipality may regulate the differential in price between self-service and full-service gasoline. A home rule unit may adopt regulations relating to contracts between landlord and tenant. Another one that really affects realtors, so I get it. Even in the areas where partial preemption has taken place, home rule communities still have the power to supplement state law so long as the local ordinance does not seek to reduce state minimum standards or provide for a lesser penalty than state law imposes. One of the examples I read about this, guys, is when somebody in Chicago wanted to get financials because they were in a dispute with their condo association. They went in and they said, hey, the municipality says that you have to provide me with these financials within 24 hours and yada yada. The condo association didn't provide those and fought it and went to the state. The state said, no. Our statute says a week or 7 days or whatever it was. They are saying 24 hours. They are allowed to do that, and you must produce them. So that is one of the areas where you may be able to advocate more for condo owners and for rights of property owners, in the sense that the municipality is looking out for disputes like that and making sure that they're handled swiftly and giving the power to that property owner or that condo owner. So zoning and subdivision, I wrote TIF as a question mark here. In matters of zoning, subdivision, control, and planning, home rule municipalities may make procedural changes as long as they meet the tests of due process, equal protection of the law, and other constitutional guarantees. Municipalities possess broad basic zoning authority, which is only expanded by home rule powers. Home rule units may zone landfill sites as long as standards similar to those in state environmental law are utilized. Any extraterritorial jurisdiction for zoning still depends upon the grant of the powers contained in Division 13 of Article 11 of the Illinois Municipal Code. Extraterritorial subdivision control and planning is still subject to Division 12 of Article 11 of the Illinois Municipal Code. So I think long story short is that they can sort of control the land and the zoning and that kind of thing, which, oh boy, I don't know. Is that a good thing? It can be. If we were home rule, would we even need to take TIF to referendum? Would we even have a say? Would we have obviously we wouldn't have a say in what they charge the retail that comes in. So, I found it interesting. I think I handled it the right way with Frank, but I found it interesting that the TIF is coming up around the same time as the home rule. Although to the credit of them, I think that's an unfair argument, because they want to move forward with the TIF for the general intention of bettering this town through commercial and retail growth. So that, trust me guys, like I said before, that's not going to happen overnight, but they're trying, at least with the implementation of a TIF. So I don't know if they had home rule powers, would they be able to move more quickly on something like that? Probably. And but now, who knows? Does that mean then that the TIF gets put in place, right? Okay, so now something wants to come in. Let's say some retail establishment that wants to come in says, okay, great, this will be more tax revenue for the city, but we're limited in how much we can tax them. So if more gambling or more, I don't know, maybe it's a bad example, but a strip club or something like that. Like, you have to assume that developers are going to propose anything. And it's like, okay, well, not only would that might help through the TIF, and that might, but why would we force ourselves to take a developer up on their offer given the TIF, because we're handcuffed by how much taxes we can charge them? So we have to take up another gambling establishment because we need the tax revenue to fix the streets, but we're limited on how much we can charge them because of state law or state code or whatever it is, state regulation, that we can only charge them $40 a machine, and we could be charging them $1,000 or $2,000. These are, what I understand, they're cash cows, and so it's like, I don't know. So these are not easy topics. These are not easy issues, and there's no good answer. So it's both ways. One of the things I felt was interesting was the personnel. A home rule municipality may extend the period of probation for employees to achieve full or limited tenure rights otherwise provided by the statute. A home rule community may elect to combine its police and fire departments or to grant its police chief the powers to discharge a probationary police officer, and may require its police officers to participate in the police pension fund as a condition of employment. It may also adopt procedures different from those established in the state statutes for discipline, discharge, or promotion of personnel. It may, for example, pass an ordinance granting to the police chief, rather than the board of fire and police commissioners, the power to make temporary appointments. So this is another area where I want to, I need to get a podcast going with the new chief. I don't know why they stuck to police and fire on that. It seemed interesting that they used that as an example. I don't know how that relates to village employees, so it'd be great to have the village manager on, get his interpretation and understanding of what home rule will do for personnel and those kind of things. And let's see, this one says enforcement of zoning, building, and related codes on other governmental bodies. A home rule unit may exercise the power of eminent domain in an area not established by the legislature, but the enactment may be overturned if it is vague or overbroad. So that one kind of raised an alarm for me, because eminent domain is one of those things where it's like, when we want to do something, you got to go. So an interesting one to understand, but I don't think it expanded on that in this particular source. So I'm not just leaving you with a question mark, but it's unfortunately doing that. So taxation, the most obvious one: wheel taxes, gasoline taxes, admission taxes, leasing, provided that such taxes are not based on or measured by income, earnings, or occupations, or preempted by state legislation. So, however, and when a court finds that too many legal responsibilities and obligations have been placed on a person providing a service, a home rule tax ordinance may be found unconstitutional, even if it contains a declaration that the tax is on the purchaser of the service. So even though, let's say, you put out a bunch of taxes, if it's killing a business, that's basically what this is saying. It may be found unconstitutional if it's killing a business, even if it is putting that tax onto the purchaser of the service. So, these guys can't get, overjoyed with being able to tax a certain thing when it drives businesses out of our town or makes it seem like it's just putting an undue burden on them. So, the broad taxing power may be limited or denied only by a 3/5 vote of each house of the General Assembly. An example of this expanded power is that home rule municipalities may levy a tax for library purposes different in amount from that recommended by the library board, or in an amount greater than permitted by statute. The courts will not review whether the tax levy of a home rule municipality is justified, because the power to limit such taxes resides in the General Assembly, which in this case had not acted to limit the taxing power. The cases that limited the power of a government to tax when it had a surplus of funds do not apply in home rule units. The issue is political, not legal. So let me go back and actually read the paragraph before that. It says, Illinois Supreme Court also upheld a tax on the sale of packaged alcoholic beverages by a home rule county, a municipality employee head tax payable by the employer, a municipal admissions tax as applied to horse racing events, and a municipal amusement tax when collected against a park district. Similarly, the court upheld the City of Chicago tax on boats moored in harbors operated by the Chicago Park District. So I guess that didn't relate to the further paragraph, but the paragraph I read in regarding the limited or denial of a tax, that's by 3/5 vote in the House. A lot of times what it says is they're not going to do that usually. So there's not a lot of cases, I think, where they've limited the taxes that home rule units have put in place. So the power to impose an income tax is treated separately in the local government article of the Illinois Constitution, which makes it clear that the General Assembly may authorize a municipal income tax. However, until the General Assembly authorizes such a tax, home rule municipalities have no power to levy an income tax. Elections, court decisions have indicated that home rule communities may have certain powers regarding elections governing purely local issues. For example, a home rule municipality may choose by referendum, to have nonpartisan elections, to adopt recall of elected officials, to change the clerk from an appointive to elective office, or to change the number of trustees and terms of office. A home rule unit may also hold a referendum to provide for runoff elections, but the proposition must clarify the procedure and include the dates for the runoffs and the number of candidates to participate. In 2005, the Attorney General opined that a home rule municipality may by referendum choose to elect its officers via cumulative voting or by instant runoff voting. So that one's kind of interesting because, if a set of trustees get in and then they decide they want to vote to make the term of the trustee longer, or if they want to, change things around in the election regard. So we probably one to pay attention to a little bit, but I think it takes a certain type of person or a certain group of people to want to make those changes. What for? So I don't see that being an issue here, but you never know. I mean, we have to consider everything. So in financial matters relating to the expenditure of its funds, a home rule municipality may not or need not be bound by state law requiring prior appropriation. So that is exactly what Kathy was saying. We don't have to abide by the $200,000 that we collect in hotel motel tax being spent only in certain ways. We can then divert that money if it's necessary. Home rule municipalities have full power to levy special assessments in order to make local improvements. Okay, so this is the one that I think is interesting, because in order to, let's say, fix the alleys, you levy a special assessment, and then that gets spread out among the owners affected by that special assessment. That's how Frank explained it. And home rule municipalities have full power to levy those now. So one to pay attention to for sure. The General Assembly never may take away this power except by constitutional amendment. Under the 1870 Constitution, a municipality could levy special assessments only as authorized by the General Assembly. Moreover, under the 1970 Constitution, home rule municipalities may exercise their special assessment power jointly with other local governments. Special service tax areas, home rule and non-home rule, the power to in the 1970 Constitution grants. The 1970 Constitution grants all municipalities, home rule and non-home rule, the power to levy or impose additional taxes and to incur debt to finance special services such as streetlights, paving, and sewers in certain areas within the municipality. In the past, by reason of the tax uniformity requirement, all the taxpayers of a municipality were required to pay for a new project financed by general taxation, even if it served only a limited area of the municipality. The Illinois Supreme Court has held, however, that no property taxes may be levied to support such projects without specific enabling legislation. Such legislation was then passed and is in effect. A home rule community may also elect to exempt certain property within a special service area from tax otherwise payable. A home rule unit may extend a special service area tax based on a standard other than assessed value, but it may not force a county to collect this tax, and must do so itself if the county will not undertake this task. Let's talk about debt. The 1970 Constitution vastly liberalized local debt provisions. In the 1870 Constitution had a rigid debt incurring limit of 5%. The Constitution establishes separate rules for debt payable from property taxes and debt payable from other sources, such as revenue from a utility, corporate funds, and taxes other than property taxes. A home rule municipality begins with the unlimited power to incur debt payable from property taxes. The General Assembly may limit this power by establishing statutory debt limits and referendum requirements for bonded debt payable from ad valorem, imposed at a percentage rate against the value of the item taxed. Property taxes. However, the General Assembly may never set limits lower than. So let me read that again. A home rule municipality begins with the unlimited power to incur debt payable from property taxes. The General Assembly may limit this power by establishing statutory debt limits and referendum requirements for bonded debt payable from ad valorem property taxes. Ad valorem meaning imposed at a percentage rate against the value of the item taxed. However, the General Assembly may never set limits lower than 3% of the assessed property valuation if the municipality has 500,000 people or more, 1% of the assessed property valuation if the municipality has more than 25,000 people but less than 500,000, and 0.5% of the assessed property valuation if the municipality has 25,000 or people or fewer. That would be us, number 3. So let me bring that to a summation. However, the General Assembly may never set limits on taxation of property taxes lower than 0.5% of the assessed property valuation if the municipality is us, having less than 25,000 people. The sale of such non-referendum debt may be authorized by the passage of an ordinance enacted by the corporate authorities. Since the passage of the Constitution, no statutory limits have been imposed upon the debt-incurring powers of Home Rule units. Laws presently in force that allow the establishment of tax caps throughout the state do not limit Home Rule debt. So we've seen some people that were knowledgeable say on Facebook that, 8.6, 8.25, it's somewhere in here as well, is the debt limit on non-Home Rule. So with Home Rule, that is not limited. So, okay. Let me look into this here because internal organization. All municipalities have the power, subject to approval by a referendum, to adopt, alter, or repeal those forms of government provided by law. All municipalities, by referendum approval or as established by statute, may provide for their officers, their manner of selection, and their terms. This latter provision will allow experimentation with voter approval in the basic rules by which elective officers are chosen. In Clark versus Village of Arlington Heights, the Illinois Supreme Court upheld the actions taken by Arlington Heights in increasing the size of its legislative body and providing for the office of the clerk to be appointive. The village took these actions only after a proposition authorizing such charges had been approved by the electors. While, in the Clark case, a referendum was required, it is now clear that with regard to all officers whose positions are not an integral part of the form or structure of government, a Home Rule municipality may alter such positions merely by ordinance. What I understand this to mean is that if you have a clerk, you can alter the role they play. In the absence of a successful referendum, Home Rule powers may not be used to diminish the power of elected officials in such a direct manner as to shift the checks and balances written into each form of government authorized by statute. Thus, the legislative body in a Home Rule municipality may not take the power of appointing officers away from the mayor by seeking to convert these offices into employments that would be filled by the legislative body. A commission-formed municipality, though Home Rule, may not deprive a commissioner of the power to hire and fire departmental employees and transfer that power to others without referendum approval. For the same reasons, an attempt to adopt an ordinance to change the vote necessary to override a veto by the president of the county board in a Home Rule county was found to be an attempt to alter the form of government without the required referendum. The court also found that an ordinance that attempted to add a third commissioner to the county board of tax appeals, stagger terms, and change the manner of election was an illegal attempt to alter the board without the required referendum. However, a Home Rule municipality may change its rules of order to require a different vote to pass a particular matter than that required by state law. That is, I think, a scary one. I don't know. If you can vote to pass, vote to require a different vote to pass a particular matter, I don't know. Maybe we need to check on that one a little bit more because the fact is, it says here, a Home Rule municipality may change its rules of order to require a different vote to pass a particular matter. It's a powerful one. Home Rule referenda. Home Rule referenda generally succeed when the officials can point to some specific reason why the increased powers would be beneficial to the community. 2, the public trusts its government. And 3, the residents have been educated and informed about the reasons why their leaders seek home rule powers. In one municipality which achieved home rule by referendum, the issue was the ability to sell long-term bonds in order to buy a large park site. In other communities, the issue has been the ability to regulate and tax a local amusement. Where the community has no central goal in mind, critics have often convinced voters that home rule is synonymous with higher taxes. Actually, real estate taxes tend to decrease or grow at a slower pace in home rule communities because home rule communities can tap other sources of governmental funding besides real estate taxation. Often the funding source is one that directs new taxes to businesses or industries that are major users of municipal services. I don't know if I agree with that. I don't know what the studies and the statistics say. There is somebody on Facebook who has mentioned that they feel like home rule municipalities have higher taxes. And so I don't know if that's the case. I would like to see more research done on whether or not we really are one of the lower taxed municipalities and the fact that we're non-home rule. And I'd like to see statistics on what's out there for the surrounding communities that are home rule, etc. Hillside I don't think has higher taxes necessarily than us, or that much higher taxes than us, and they're home rule. So this needs weeded out more. So perhaps one of the people that I'm interviewing can explain that or has looked into that. I'm hoping that it comes from an authority like that. But I'm going to do the work a little bit myself. And if you fellow residents can do some of that digging, let's find out so that we know whether or not we actually are in a lower tax bracket and whether or not we're being taxed less than home rule communities. So while a home rule unit may exercise its expanded powers, I promise we're almost done. I just want to get through this because it's got to be memorialized in this way so that you guys can listen to it when you want to and try to discern for yourself. While a home rule unit may exercise its expanded powers by actions other than ordinances, it has not yet been determined whether the community must specifically pass an ordinance to override a state law that would otherwise bar the validity of its acts. In one case, a county awarded health care contracts without competitive bidding, and the court allowed the practice without any apparent local ordinance modifying the provisions of the state statutes. In another case, the court found a home rule community's contract was invalid because the city had failed to pass any ordinance reversing the statutory requirement of a prior appropriation. For that reason, it may be wise, though not required, to indicate that an effort is being made to change state law. Some communities do this by indicating in ordinances that the enactment is being passed by the municipality in the exercise of its home rule powers. So they're basically saying to the state, we're doing this in our exercise of home rule powers. Let's say Westchester wanted to give a contract to somebody without competitive bidding. If it's required by state, they would have to hopefully have an ordinance or be able to state that they're doing that given their home rule authority. Home rule municipalities may also impose fines greater than state statutory limit. Home rule municipalities may imprison offenders for up to 6 months. These are some of the ones I think are positives. I know that it's back and forth and it's different issues have positives and negatives, but this is one of them. I think fines for certain things that you do within the village. This is a murky area. I get it that if you do something wrong, you should be fined, but those fines might be able to be higher. A lot of people are making a big deal about blowing through stop signs. I don't know if that's something we're going to talk to the police chief. I don't know if that's something that could be changed in terms of the fine for that. Maybe we just need to be more diligent about catching those people so we stop doing it. But other things fall under this category too that, I don't want to see all of a sudden, we have licensing for dogs, and all of a sudden now in order to have a dog in the village, you have to have a license, or, you get fined if your dog does this or that, poops on someone's yard or something like that. I don't know, like that. I think that's the stuff we need to stay away from in regard to home rule. How does the legislature limit or remove powers from home rule units? I'll put the link up to this. I don't really want to go into that here. Sounds boring. Are the powers of a home rule unit unlimited if the legislature does not preempt the power? Good one. Are the powers of a home rule unit unlimited if the legislature does not preempt the power? No. Home rule units are still subject to all of the restrictions contained in the federal constitution and the state constitution. In addition, in certain cases, the courts have held that even without specific statutory preemption, the acts of home rule units fall outside of the government and affairs of a local governmental body or are areas of a traditional state control. For example, the City of Chicago was not permitted to use its home rule powers to impose building safety and health ordinances on the trustees of the University of Illinois, but the North Shore Sanitary District was required to follow the City of Waukegan's zoning ordinance because there was no statutory preemption. So it wasn't the state coming in and saying, no, you have to follow our rules. It was, North Shore Sanitary District has to follow City of Waukegan, but City of Chicago doesn't get to decide what goes on with University of Illinois. What can a municipality do if it no longer wants to be a home rule unit? Big question by everybody, right? A municipality may cease to be a home rule unit through a referendum. If the municipality reverts to a non-home rule status, it does not automatically invalidate all actions taken while it was a home rule unit. For example, bonds issued and contracts that were entered into under home rule remain valid for their terms, and taxes may be levied to fund those obligations. Look, this, again, I think is another one where we have to look at this closely. That means basically, to me, that if we enact home rule and they decide to take out a bunch of debt and under certain terms, and then that debt needs to be paid for, they can still tax, even though we say, whoa, you got out of control, we're taking your home rule authority away. That means that those contracts, those issues that they put in place, now they might be thinking they're doing it for the good of the village, and they might say, well, we need this, okay, but it still could handcuff us to the point where even if we rescind home rule, we're stuck with these contracts and these issues. So something to think about for sure. Do we trust the people that we have in place and that we'll continue to put in place to do this? And I think that's why this is such an important podcast, is because I want to continue this. I want there to be a State of Westchester podcast where we have on all these people, or we at least have on, the village president, and he gives a state of the village address and talks to us about that and tells us where is our debt levels, what is our budget like. If that needs to be in conjunction with the treasurer, great, But I think that in certain ways, if you're running on transparency like this board has done, that's okay. They're going to be okay with it, and so far they have. I think it's great. They're okay with that, and let's test that, because we certainly want to make sure that we're getting the best for Westchester. And I mean, think about it, guys. I mean, if they're using these powers wisely, who knows? Maybe this could be one of the best things that's happened to Westchester. And I hear so many good things about Westchester from other people, and it could just jump it even further. We could start seeing people building up. We could start seeing our schools really improving. We could start seeing a lot of great things, lots of good retail coming through. You'll get your Culvers, maybe. I don't know. That one's for you. You know who you are. Anyway, liberal construction of home rule powers. Courts must construe grants of home rule powers liberally. Previously, where a municipality had only those powers that were specifically granted to it by statute, such powers were narrowly construed by the courts. Thus, if a statute allowed a municipality to license dogs, the municipality could license dogs, but could not necessarily license all other animals based only on this one statutory grant of authority. Now, home rule municipalities may license dogs, cats, monkeys, and anything else within its government and affairs, unless the state specifically preempts or restricts this power. What happens if there's a conflict between a home rule county ordinance and a municipal ordinance? If a conflict exists, the municipal ordinance prevails within its jurisdiction. If a case involving a tax imposed on the sale of motor vehicles, the Illinois Supreme Court has held that no conflict exists and that both taxes are valid. While double taxation does not cause a conflict, a true impasse, height of offense, number of liquor licenses, etc., would be resolved in favor of the municipality. What powers do non-home rule municipalities have? Non-home rule municipalities will continue to be governed by authority they are given in the state statutes. Some of those powers include the power to make local improvements by special assessment, which may be exercised jointly with other municipalities, counties, and special districts authorized to make local improvements by statute. The power to enter into joint assessments may not be removed by the General Assembly. 2. The power to adopt, alter, or repeal their forms of government from among those forms provided by statute if their citizens approve the change by referendum. Since this language is identical to that accorded to home rule communities, there are now substantial changes that could be considered by non-home rule communities. For example, such a community could approve an appointed clerk and modifications in the composition of its legislative body. 3. The power to conduct a referendum regarding officers who are central to its form of government, to set the salaries of its officers, and to determine the manner of their selection and terms. A referendum may also be held to provide for nonpartisan elections. The General Assembly may not remove this power. The power to incur debt in any amount and in any manner allowed by the legislature. However, the debt limits for non-home rule municipalities are subject to statutory enactment and may be changed more easily as conditions demand. The non-home rule debt limit is 8.625% of the municipality's assessed valuation. Municipalities are also able to extend debt payments for debts payable from property taxes over a 40-year period. Okay, I'm done. I know it was a lot of information. I know it was not always fun, but I got it out there, and I think it's good for people to think about these things. I think it's good for them to look them up. So I will include the links to these. You can read them for yourself. This is not all encompassing, so please look all around in every corner for whatever articles, whatever things you can find. If you're against home rule, I'm sure you can find something, plenty of things that would be against home rule. If you are for home rule or you think it might be a good idea, I'm sure you can find a lot of stuff like what this was saying where these powers aren't always that bad. Certainly there's some areas of caution. So coming up, thank you for listening. Coming up, I am hoping to have on Mike Gober, who is a real estate managing broker in the area. I hope to have on the treasurer, Barbara Brandt. I hope to have on Paul Nosek, who is the village manager, Paul Gattuso, village president, and among etc., like all of them, everybody. If you think that it's somebody to have on that has a voice or that should have a voice or that has an understanding that we're not getting, please make that suggestion. I am open to all suggestions. The one thing I am against is the idea that we have only this limited amount of time to get this out and to create an informed voter base. Okay, please, I want to make that clear. I am giving these people the benefit of the doubt. I will not attack them. I will not play gotcha. I am doing the best I can to start slow and to give everybody an understanding, an idea of what their character is, where they came from, who they are, and then maybe that gives the ability for me to challenge them a little bit more so that we can get an understanding of what they want to do with this. I am Ryan Joseph on Facebook. I have my real estate license, and it's a real estate flipping and renovation company. If you want to look into buying or selling a home or hiring me for renovation, that's great. I appreciate it. I'm going to try to do both. I'm going to try to maintain this podcast and maintain a business, and we're trying to figure this out together. So please spread the message on Facebook, and any way you can. If you've got, grab the YouTube link and send it in an email to all the people you know live in Westchester. I'm going to try to get that started too. Any way that you think you can to get this information out, I think is a good idea. So I'm not the only authority either. So please come to the meetings if you care enough and you want to, which that's not a challenge to you. I'm just saying I didn't care either. I didn't vote in the last election. So trust me, I understand. I'm not being hypocritical. I'm just, I've had enough, and I'm doing my best to change how I operate within this village. So thank you. I appreciate it. Until next time.